Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-3214 et al. United States of America versus Joel Sorto, appellants. Ms. Bederman for the appellants, District Court's failure to hold a hearing and ineffective assistance of counsel regarding Spanish tapes. Ms. Fernandez for the appellants, ineffective assistance of counsel for failure to pursue entrapment and selective enforcement. Mr. Cahill for the appellee.
Good morning, Judges Wilkins, Rao, and Walker. I'm Donna Biederman. I'm here arguing on behalf of all three of the appellants on the issues of the fact that there was not a hearing upon remand and the Spanish language tapes. Ms. Hernandez will then argue on the issue of entrapment and on selective enforcement. In 2017, this court sent this case back to the district court for a hearing and asked the district court to answer three questions. The district court did not hold a hearing. The three attorneys filed affidavits. That's the only additional evidence in this case at all. And the district court did not hold the hearing and denied it. Those three questions that were sent back to the district court were not answered because there was no hearing here. So the first of those questions is why defense counsel failed to pursue entrapment. The second is why they did not object to the admission of the Spanish language tapes and what conversations they had with their clients, and also whether appellants advised their counsel that the testimony was not an accurate account of the conversations. And the third question is the extent of the prejudice from not objecting to the Spanish language tapes. I'm going to take those in reverse order. The first one being the extent of the prejudice from not objecting to the Spanish language tapes. There is nothing at all in the affidavits that addresses this question. And in fact, there couldn't be anything in the affidavits that addresses this question. Therefore, that question wasn't even addressed at the district court upon remand.
Well, what if you had a hearing, what would you have put in evidence about prejudice?
What we would have put into evidence about prejudice is that the entire case was changed because of the Spanish language tapes, that there was enough evidence to show that the defendants had shown up, the appellants had shown up with guns, but there wasn't enough evidence without the tapes to show that they had conspired to commit the robbery.
That sounds like argument, not evidence.
That is partially argument and partially evidence because it changed the whole way that the status of the case was, and there would
new evidence. What's the new evidence in the answer you just gave?
The way that the case would have been presented to the jury, what the jury would have heard would have been new evidence there.
That's I don't follow that. I mean, that's an argument. That's an argument about how the trial would have been different, but you don't put on a witness to testify about how the trial would have been different.
That is partially an argument, and partially it would have come out at the hearing as to how the case was different. There wasn't enough evidence on that in the argument that was put on yet. The second one is that
what witness would you have called?
I think
that new evidence.
I think that the defendants themselves would have been able to testify as to some of that.
Were they able to file affidavits?
They were able to file affidavits, but the court remanded for a hearing. And
trying to figure out what would have happened at the hearing that couldn't have happened in the affidavits.
Well, as to the Spanish language tapes by themselves, or as to everything, because there is more that would have happened that they would have put on evidence. First of all, I haven't gotten to the other two questions yet, but one of the questions was why the defense counsel failed to pursue entrapment. And the counsel put in affidavits, the defendants didn't have a chance to testify as to what happened there, right? They didn't have a chance to testify as to, the defense counsel said that the reason that they did not pursue entrapment was because their clients didn't want them to. As a matter of fact,
Seems like that goes to deficiency, not prejudice.
no, what goes to deficiency, not prejudice?
Your client's possibility that your clients could have rebutted the attorney's reasons for not pursuing an entrapment
Goes to sufficiency of the evidence?
would have gone to whether counsel was deficient.
Correct.
But
It would have
doesn't
gone
seem-
to,
But it doesn't seem like it would go to whether any deficiency was prejudicial.
I think it would have gone to both because it would have shown, how they could have gone forward without it, what the trial would have looked like without it.
Wait,
I would like to-
How? What could they have said?
They would have said that they did not tell their counsel not to pursue this, that they wanted to go forward with the strategy, and that they wanted to pursue the entrapment. Now, I will like to point out that Mr. Lovo, Mr. Sorto's attorneys did say it was because of the client's preferences. Mr. Ashetu's attorney didn't even address this question in his affidavit. There's nothing on the record at all from Mr. Ashetu's attorney.
I think where you need to try to go here is the government says we can concede that counsel was first part of Strickland. Even assuming that they were deficient, you have the burden of showing that there's a reasonable probability of a difference in the outcome, the prejudice.
Correct.
So whether the lawyers, would have testified about why they did or didn't pursue it or whatever, kind of beside the point here, because we're presuming that they were deficient, that was a mistake. We're just going to presume that was below the standard performance. So talk to me about prejudice.
Well, Your Honor,
Reasonable probability that the outcome would have been different.
as I said, the entire trial would have been different without these tapes, because what they did is the government showed tapes from 4 different days. And what they did is they showed part of the tape, they paused it, they then asked questions. The government's witnesses then said, this is what we're all saying here. And then they started it again, and then they paused it, and then that went on and on and on throughout the trial. And
I understand that the trial would have looked different, it would have proceeded differently, but presumably then they would have just, without the tapes, would have just testified, this is what we said on this day at this time, and this is what happened and what was said by everyone. And because the defendants, their statements are admissible as admissions by a party opponent, the government witnesses don't need the tapes to testify about what they say the defendants said. So wouldn't all of the substance of the conversations, at least according to the government, wouldn't have that come in anyway?
it bolstered their credibility by showing these tapes that nobody could understand what was going on, that we didn't have transcripts for, that were in Spanish, that were inaudible. The professionals that tried to take it down wrote they couldn't even figure out what was happening on them because they couldn't write it down into the transcript, which is
Then
part of the
why
problem.
isn't the reasonable inference from that the jury didn't really credit the tapes for anything? For one, they probably couldn't understand most of it if that was in Spanish. And 2, if the tapes were so bad, then how could they bolster credibility? Because the jury would have been like, I don't see how this corroborates them because no one can understand what's on these tapes.
because they were showing what was going on, and then the government was saying, oh, this is what's happening here. And the government, and then they would show the next part, and the government would say, oh, this is what's happening here. And there wasn't a meaningful way to combat that or to argue against that because there was no transcript of the Spanish language tapes, and they were inaudible. And the other thing I would like to point out is that had there been an objection to it, when it came up in 2017 and this court found that it was error to have these tapes there, it would have been found under a different standard. This court found that there was error, but that it didn't raise to the, that they couldn't find on the record that it raised to the level of plain error because there wasn't enough about prejudice on the record at that point, and that's why it remanded for a hearing. If it had gone up.
Are you contending that to the extent that the tapes were videotapes and had audio, and that the audio part couldn't have been admitted, are you saying then that the video should have been excluded also?
I'm saying that is an argument that the defense attorneys could have made. I don't know which they would
We
have.
didn't find that in our first.
Correct.
And you
but-
didn't make that argument as best as I can recall in the first appeal. I'm not you, but the defense did.
Right. They didn't make an argument at all. The trial defense counsel didn't make an argument at all to exclude them.
So my point is that even if the trial had proceeded properly, then there would have been video and no audio, right?
There could have been. It's
They-
possible.
They would have proceeded in the same way, but saying this is what happened here and this is what we were doing, this is what we were saying. It would not have been bolstered by the audio, but it could have been bolstered by the video, right?
There's parts of it were videos, parts of it was just audio. And it's impossible to separate out which part of it was prejudiced by which. But in my point there was that if the defense counsel had objected to it at the trial court, there's two things that would have happened. Either the trial court would have kept them out and they wouldn't have been there, or the trial court would not have kept them out. And when it was appealed and came up to the Court of Appeals, to this court, it would not have been under the plain error standard. It would have been under the harmless error standard. So the fact that they did not object to it is itself raised the level of prejudice that they needed to show and the level
Do you have
of
any
error.
authority for that proposition? That seems to be for the proposition that that's ineffective assistance. I mean, we hear plain error cases every day on appeal.
Yes,
And it doesn't get turned into ineffective assistance because they failed to object and we are under a plain error standard instead of a harmless error standard. It seems like that just throws a monkey wrench into how we review criminal conviction.
I don't think it does because this court has found that there's error, right? So the question is, what is the standard of review and the level of review that you need to put on there?
So in every case where there's a failure to object and we review in a criminal conviction under plain error, that's also the basis for an ineffective assistance claim.
No, but in every case where you send the case back to the district court and say, tell us about the prejudice, then that can be a significant issue as
How does the
to,
district court want to assess the prejudice from a failure to object on appeal? That's not what they're assessing. They're supposed to assess the difference in the outcome of the trial.
correct. It's not a failure to object on appeal, it's a failure to object at the district court. And the standard would have been different when it came up to this case, to this court, and when it came up to this court, the court would have overturned it at that point because of that error that the court found.
Given the time, why don't you move on beyond the tapes to, I think you were going to address another issue?
The other issue was the fact that they didn't hold the hearing. So at this point, I will cede the rest of the time to Ms. Hernandez, because I think we covered that unless you have any other questions about our argument.
All right, thank
Thank
you.
you.
Good morning, Ms. Hernandez.
Good morning, Your Honors. So a little bit of background. I represented Mr. Lover for sentencing below because all three defendants fired their lawyers after they went to trial and lost. And I appeared before this court for the appellate, for the first appeal. Deficiency. My client was a young man, and this goes to entrapment. My client was a young man working more than 40 hours a week. He lived in DC with the mother of his child and the mother-in-law. He worked in Baltimore County, more than an hour away, generally more than 40 hours a week. I obtained his work records for purposes of sentencing. The trial lawyer did not have that.
We don't need to argue deficiency. As I said to your
Okay.
colleague, the government is conceding that for the purposes of this argument. So focus on prejudice.
Well, the prejudice, you don't need prejudice for entrapment in this sense. You can be guilty and still be entrapped. That is, you can admit that, in fact, entrapment essentially says, I did
You need to show a reasonable probability that the entrapment defense would have succeeded.
Well, that's my point. First of all, his lawyer, his trial, I'm sorry, Your Honor.
I think that's what Judge Wilkins was.
Okay, so his trial lawyer issues an affidavit, sends an affidavit to Judge Cooper and says it was a strategic decision. He can't make a strategic decision when he hasn't obtained his work records from a reputable company
That's deficient. That's deficiency.
That's deficiency, and that also undermines his argument that it was a strategic decision. You cannot,
Deficiency too. What's the prejudice?
on an entrapment defense,
What is the reasonable probability that it would have succeeded?
it meets all the requirements for entrapment, and it's a jury issue.
How?
Like,
How does what meet all the requirements for entrapment?
He was induced by his friend for over a year to buy drugs. When that didn't pan out, they then brought in this supposed reverse sting robbery. Two, they said it's an easy thing because we have an inside job. Three, the friend called him 131 times, which was an out of the ordinary event.
Did he call him 131 times about the heist?
He called him 131 times when the phone records reflected in the
I think
two.
your answer is we don't know.
Right, but that goes to a jury. During the,
You didn't proffer any evidence, as best as I can tell, but correct me if I'm wrong, of what was the content of any of those 131 calls.
there's an inference to be drawn when the phone records show
Yes or no about whether you
Only an
proffered any evidence about the contents of the call.
only the inference, Your Honor, which the government produced, that's the government's cases every day, right? The inference to be drawn from the fact that the friend called him 131 times in the 2 months before the robbery was to take place, when normally he wouldn't make those calls.
I think, let's concede that like you tell me, would you concede that the very first moment, like the first 2 words out of the officer's mouth or the friend's mouth, that alone right there would not have been enough for entrapment? The first 2 words out of their mouth, right?
I don't understand. What do you mean by the first?
Presumably you think there was entrapment and that entrapment occurred at a certain point in this story.
The
It
entrapment.
went from being non-inducing to inducing. It went from being non-entrapment to entrapment.
I think it was entrapment from day one. They used a friend, a close
Right?
friend.
What was the first, what happened on day one that made it?
On day one, when they purchased the second small quantity of drugs and decided this isn't going to play out as a federal drug case, so we're going to go through this reverse sting, the defendant testifies at trial that the officer told him, the undercover officer tells him that maybe we can give you a job, a construction job, because we're trying to fix this office and blah, blah, blah. The officer on the stand doesn't say it didn't happen, says, I don't recall.
Okay, but let's take that. Let's say it happened.
Okay,
Right there, what you just said, that satisfies all the elements of a
No.
successful entrapment. Okay. At what point in the narrative were all the elements of a successful entrapment defense satisfied?
entrapment requires inducement.
I don't need the rule explanation. I need the rule application. At what point in the facts of this case did the conversations with the officer and the friend go finally satisfy all the elements of entrapment?
Well, first of all, that's a jury issue. Was there entrapment? And second of all, I would submit to the court that it is,
What point should the jury have found that if you'd gotten to present?
When
all
you
the
put
evidence you
everything-
wanted, at what point in this narrative did it become entrapment?
when you put everything together.
So at the very end, the last sentence, the last word that was spoken, it
I-
wasn't entrapment until then, but at the last word that was spoken, it became an entrapment.
I don't understand the court's question or why the court is going there for this reason. As every jury issue, I don't know that I can point to one single fact or event that brings it there, but when you take all
I'm
the
not saying it would
facts,
have to be that fact by itself, but it would be that fact plus all the facts that came before it.
right,
That fact would be the straw that broke the camel's back. That fact would be when the line was crossed from not inducement to inducement.
I don't know that this or any other case can point to a point where it goes from non-inducement to, everything in this case is true. Mr. Lobo was entrapment.
Let me,
Everything.
let me put it this way. Let's suppose the instruction had been given, the entrapment instruction had been given. And the evidence that was proffered to the trial court had been introduced.
To which trial court, Your Honor? To the actual trial?
Whatever you presented on remand
Okay.
and whatever you had presented prior to remand relevant to entrapment had been introduced. What is your
So
60-second closing argument to the jury based on those facts, based on that evidence that they should find entrapment?
I have a young man working more than 40 hours a week, traveling back and forth, supporting his family, no prior convictions for robbery or anything like that. They send his friend for more than a year to try to get him to sell drugs. Minimum $700. So then they then tell him, we're going to help you, we're going to hire you to do this reconstruction. When the messaging always comes from the undercover to my client, and half the time my client is, I'm at work, I'll call you back. There are 131 calls from the friend just before this thing happens, and then he shows up. And I would submit to the court, Your Honor has been a trial judge. Juries love to hear that the defendant was employed full-time, not by his cousin, not 10 hours a week, with timesheets. His employer for sentencing came in and said, sent a letter, said, I would hire him, even knowing the conviction. I would rehire him because he was such a good worker. I submit to the court, I have a chance with that jury. I have a chance with at least one juror. And the fact that the trial attorney, who I know and who's a very good trial attorney, did not get his work records, it's not just the defendant saying I worked, right? It's concrete evidence. The fact that did not get the phone records that showed these inordinate number of phone calls, it's deficient. How can you make a decision whether entrapment's going to play or not if you don't have basic information about a case?
The 131 phone calls, those were, if I recall right, from June to August.
From June 15th through August 24th of 2013. Those are just the phone calls. That doesn't mean there weren't meetings and everything, but I'm just.
Understood.
And again.
Did you proffer evidence of how that compared to the frequency of calls prior to June 15th?
Yes, the phone records reflected that was an extraordinary number of calls. In other words, if you look at the phone records that we received, he wasn't calling, 131 calls is almost at least one a day. That was not the frequency. And most of the calls were coming from the friend to my client. And my client's at work. So
All right,
If you're finished,
go ahead.
anyway, I'm way over, Your Honor.
I thought of a clearer way to ask the question that I think I probably was inartful in asking. So this is a quote from Glover. The government's behavior amounts to inducement when it was such that a law-abiding citizen's will to obey the law could have been overborne. And I'm wondering if you can tell me at what point was his will overborne?
He's a young kid with a lot of, with a very difficult childhood, absent father. The friend knew it.
The point when his will was over,
It was,
at what point was his will overborne?
I don't, I'm sorry that I don't, my view as a trial lawyer and as well as a human being is that there's no single point where something happens. It builds. It builds.
Maybe just at what point,
At the
Can you
point
give
that
me
he
a-
showed up.
the point that he showed up?
Well, I mean, I'm just saying the
He was
whole,
just- he
the
was
whole,
just born to be overborn.
well, he has no prior convictions, no evidence of no prior convictions or charges for armed robbery or violent crime.
I mean, I think you would.
The
concede-
friend starts,
Would you concede that someone who had lived the best life imaginable, okay? And the government agent says, would you like to do a robbery? Is he induced at that point?
no, but the friend starts contacting him in July of, the first 14 grams of cocaine are July 24th, 2012. This is a close friend of his who has nothing to do with any of these defendants, who's caught on a drug case of his own and starts, because he's working for the cops, doing this. The other thing is that the government didn't do, which they do in cooperated cases, is that they could have taken the friend's phone and monitored it. I've had cooperators, the government makes my client sign a document that says, we can monitor your calls, so we know what you're talking to.
I have
I'm
it,
sorry.
sir, and I'll give you one chance to, I'll give you a chance to respond. to
Okay,
my
I'm
last
sorry.
question. If your argument is that the inducement to break the law began before the government even spoke a single word, that's a hard argument.
No, because the government, my argument is the government is speaking throughout. The friend reaches out to my client in July or before July. That's the first time he gets him to give him drugs, a small quantity, because he's working for the government. So the government is putting him up to get me some snacks. You want to reduce your sentence, you got to bring me somebody. So my argument to the court is that everything that the friend's not reaching out to my client because he's doing it because he wants to get my client in trouble. He's doing it because he's being told, if you bring me another head, we can give you a reduction. And the friend was out the whole time. And the friend, the jury never heard any of this. The jury never heard any of this. And the question about when it's induced, Jacobs, the Supreme Court case, Jacobson with the porn and everything else. It's multiple times that happens, multiple events that bring somebody overboard. And again, maybe I would never have been, but my kid is just a young man with, limited education, difficult childhood. The fact that he was employed full-time, he was here legally. Maybe he's not a perfect human being. And maybe the fact that his friend knew all sorts of things about his personal life that would have made him susceptible to some of these entreaties. So it just.
You didn't proffer testimony about any of that.
About the friend, I argued.
Well, you didn't. The counterfactual that we have to assess is what evidence would have been presented of entrapment had that evidence been pursued properly by the lawyers and then the instruction was given.
All the arguments that I'm making were made post-verdict.
But what I'm saying is that what you can say at sentencing or to a judge is different than what a jury would be allowed to hear.
Well, I made all those arguments in the motion for new trial in the district court. But yes, the client could have testified to some of that.
But you didn't proffer that your client was going to testify to any of that.
I proffered that those were the facts, unrefuted facts about his personal background. They're in the pre-sentence report. So this is unrefuted facts about his personal background, his father being absent, all his difficulties, the fact that this is a young man who's a friend of his for a long time, all those facts were proffered, who I would have put on the stand to testify to that, you know, that was not an issue. And the motions, there are multiple people who could testify to such things. His wife could have testified, he could have testified, different people in his life. You know, he dropped out of school and all of this, all those things.
All right, well, I think we have.
I'm sorry. Yeah, thank you so much for going on.
Thank you.
May it please the court, Timothy Cahill for the United States. The district court's ruling should be affirmed because appellants have failed to show prejudice on any of their ineffectiveness claims and have not identified any evidence outside the record bearing on prejudice that would have required an evidentiary hearing. First, I wanted to clarify and emphasize that the remand order from this court did not expressly order a hearing. In following the typical practice of remanding what this court viewed as a colorable ineffectiveness claim, this court was giving the district court, in the first instance, the opportunity to do a robust review of the trial evidence and any proffers or additional evidence outside the record that appellants were able to present, and then evaluate whether a hearing was necessary. The district court did that in this case, and as we've argued in our briefing and happy to argue here, reached the correct conclusion that no prejudice was shown on the existing record and there was no proffer of any disputed facts that could have affected that prejudice ruling. With respect to the Spanish audio issue,
Let me ask you about that. I mean, we said that on this record, we don't know why defense counsel declined to pursue the entrapment defense. Okay, so that goes to deficiency. And then we said the record does not contain sufficient evidence for us to weigh counsel's performance or any resulting prejudice. So if we couldn't weigh it, given the record, and we send it back, then how could the district court judge, who wasn't the district court judge who tried the case and saw the witnesses and heard the evidence, how was that district court judge in a better position than us to weigh prejudice? If we couldn't weigh it, then how could the district court have weighed it without a hearing?
So I would have two responses to that, Your Honor. The first is, in remanding on that basis, this court, I think, implicitly at least, recognized the possibility that on remand, additional information could be presented by appellants that would have necessitated a hearing. They were given the opportunity to do that on remand and didn't do it. The second thing I would want to note is that while it's true that the record of the trial has not changed since direct appeal, with respect to the ineffectiveness claims, that was not the focus of, frankly, either party or the court on direct appeal. There were Fourth Amendment and crime of violence issues that comprised in a 70-page brief and a 90-page brief, all but about 5 pages of those briefs. The ineffectiveness claims were treated in pretty cursory fashion.
Are you trying to say that we didn't mean what we said when we wrote that the record does not contain sufficient evidence for us to weigh counsel's performance or any resulting prejudice?
But certainly with respect to the prejudice, Your Honor, I think the record presented to this court on direct appeal was maybe not as robustly developed and analyzed and addressed, and that the district court, as is this court's typical practice, the district court is in the best position in the first instance to do that sort of robust review of a fact-intensive issue with the parties exploring the trial record in depth and, again, giving appellants the opportunity to present any evidence they thought was relevant to that issue but may have been outside the record. And having
the court didn't say that the record as we have it, or the record that was presented to us, it says the record does not contain sufficient evidence for us to determine prejudice. And again, we say later, in that same paragraph, nor is the extent of resultant prejudice, if any, clear from the record. And we therefore remand for consideration of this challenge as well. That's with respect to the the tapes. And we've said that with entrapment, you know, that's a jury issue, it's a fact-bound issue. So I'm just find it hard to understand why, if we said record isn't enough, sufficient for us to determine prejudice, how a district court judge looking at the same record can make the assessment.
And I would emphasize again, Your Honor, that on remand, this court having done the remand, appellants have the opportunity then to identify any disputed facts that they thought would be necessary for the district court to resolve that would necessitate a hearing. And throughout that process, and frankly, even now on appeal, through 2 briefs and an oral argument, I would submit that they have failed to identify a single disputed fact that would be determinative on the issue of prejudice. And given that posture, the district court—
I'm not sure what you mean by they haven't identified a single disputed fact.
That would—
They've identified that there were 131 phone calls. They've identified that they would have introduced work records. They would have, I'm going to ask you the same question that I asked defense counsel. So let's suppose all of that evidence came in and the entrapment defense was presented and instruction given to the jury. I don't know whether you ever were or a trial lawyer, but what would the government say in its closing as to why the jury should not find entrapment here?
So I think there's focus on the phone calls. Even if we imagine some scenario where those phone calls, the phone logs, which is all that was proffered, and that's why I say there's no disputed fact. There was no proffer about the content of those phone calls. That may have been a disputed fact that would have required resolution. But the mere existence of the phone calls, I think, would not be compelling evidence of entrapment, certainly not enough to raise a reasonable probability of acquittal, given that the contents of them would have remained pure speculation. And the only evidence we have about them, as Judge Cooper points out correctly in his district court decision, undermines any suggestion that they were part of some pressure campaign, both the length of those calls and the timing of those calls. Almost all of those calls preceded the August 13th meeting when the idea of a robbery was ever even first proposed to Mr. Lovo. So those phone calls preceded the fact that a robbery could have even been proposed. Secondly, the longest of all of those phone calls, the absolute longest one, was 2 minutes and 7 seconds long. Most of the phone calls were a matter of seconds long. I'm not going to speculate what they were, but that's all that you could, I mean, that might be, I'm running late. I mean, there's not a lot you can say in a few seconds that could overbear someone's will to obey the law.
You're going to do the robbery, right? We're on for the robbery, right? You could say that in a few seconds.
You could, Your Honor, if anyone had ever proposed a robbery. But the only evidence from either party, including Mr. Lovo's own testimony, is that the robbery wasn't proposed until August 13th. There's no evidence proffered or suggested to the contrary.
So how many calls were between August 13th and 24th?
I believe, I know that prior to August 13th was about 100 of those calls. And then after August 13th, looks like less than 20 after August 13th. I would also emphasize that according to the only evidence we have about Mr. Avila, that's Mr. Lovo's friend's role in all of this, his role ended when he accompanied Mr. Lovo to that first meeting where the robbery was proposed. At Mr. Lovo's own request, he was left out of any further proceeding. So from the moment the robbery was even on the table, Mr. Avila no longer played any role in these proceedings. And the record evidence is overwhelming that from that moment on, Mr. Lovo's predisposition was that far from being reluctant to engage in this criminal behavior, when he was multiple times given the opportunity to back out with no adverse consequences, he was the one who was insistent on following through.
Well, that was the government's evidence. That's not what Mr. Lovo testified, right?
Yes, but Mr. Lovo, the only additional testimony in this counterfactual scenario, Your Honor, is phone calls whose content is speculative, almost all of which preceded these relevant events. We would submit that that doesn't come close to establishing a reasonable probability of acquittal on an entrapment theory. So the jury was presented with Mr. Lovo and the government's conflicting accounts of what actually happened at those meetings. And they made their assessment of which testimony they credited. And so in order to show a reasonable probability of acquittal, the appellants would need to establish that what they've proffered here would have changed that assessment, a reasonable probability that the jury would reach the opposite conclusion. I would submit that given the nature of the evidence presented here, which is, again, almost entirely speculative, and what little we know about it runs counter to the idea that it was part of a pressure campaign, doesn't meet that threshold.
Now, Mr. Ashutu, really not pronouncing his name correctly, was convicted of the Hobbs Act robbery, but was not convicted of the 924 count. Am I correct on
That's
that?
correct.
And the evidence with respect to him was that, I guess, he was obviously there on the day of the, alleged robbery. But I guess here's what I'm getting at, is that Strickland says we're supposed to look at prejudice by kind of looking at the totality of the evidence, and it depends case to case, and the deficient performance and the evidence that wasn't presented that should have been presented, or that was admitted and should have been kept out. It's going to just depend in every case, kind of like how prejudicial it was or how much impact it may have had. So there's no kind of black and white way of assessing these things. And that we're also supposed to look at the strengths and weaknesses of the government's case when we assign prejudice. So the fact that Ashutu is acquitted of a count when he's right there with everybody else, and he arrived in the same car with everybody else that had all the weapons in it that the government found, doesn't that say something about the weakness of the government's case?
So in terms of the actual claims raised here on appeal, Your Honor, I would submit no, because especially with Mr. Ashutu, in terms of whether or not there's prejudice on whether or not he could have raised an entrapment defense.
Well, no, I mean, I'm just saying, if what we're supposed to do under Strickland is just kind of weigh, like, okay, this mistake could have been a lot more prejudicial here because this was a weak government case. Whereas if the case is like overwhelming with videotapes, DNA, fingerprints, your mom testifying against the defendant or whatever, prejudice there would be a much more uphill battle. I guess all I'm saying to you is, doesn't that acquittal tell us, or shouldn't we, the conclusion that we reach from that is that this wasn't really that overwhelming of a case?
And I will respond in the same way Your Honor's framed the question, which is distinguishing amongst these appellants, as in some of these claims having somewhat different circumstances and different evidence and different, frankly, legal claims. So with respect to the two claims that we've spent the most time talking about here, I would argue why Mr. Ashutu still has not shown prejudice. And first, on the entrapment defense, I would say Mr. Ashutu doesn't even get through the door on an entrapment defense because he could only raise a derivative entrapment defense. And there's been no suggestion, no proffer, no anything to indicate any specific targeting of his involvement in this case. The only evidence we have from any party is that he was present only at the invitation of Mr. Lovo, which this court has expressly held does not establish derivative entrapment. So regardless of any other evidence affecting him, on the entrapment defense for Mr. Ashutu, we submit would have been a non-starter under any scenario that's been presented. With respect to the other primary claim, the Spanish language audio, Mr. Ashutu was, Your Honor, correctly, as Your Honor correctly points out, only present at that last meeting. That was a 40-minute meeting that was entirely captured on video. Mr. Ashutu appears in that video, and when Mr. Ashutu speaks in that video, he speaks in English, giving directions to the other participants as to what they're going to do when the robbery commences. Our supplemental appendix, page 145, 154, 161 has testimony and evidence about Mr. Ashetu giving those directions to the other robbers in English. And there's no suggestion that that would have been excluded. I recognize that there was an acquittal on the 924C charge. Obviously, the government thought there was sufficient evidence. It wouldn't have proceeded on that charge if they didn't. But who knows how the jury drew that distinction? But if I were to wager a guess, it probably is the fact that he was only present at the last meeting and not the planning meetings. And the jury drew some distinction on that front. But they still convicted him of conspiracy to commit Hobbs Act robbery. And the evidence that they convicted him on would have been largely identical, especially in his case. He wasn't present at the earlier meetings where the conversations were largely in Spanish. His involvement at that last meeting was him speaking at times in English about directions to the other participants in this robbery.
But he wasn't the guy, because he wasn't at the prior meetings, he wasn't the guy at the prior meetings who talked about how he preferred machetes, right?
That was Mr. Sorto.
So if the jury thought that he was there to, commit a robbery or had reached an agreement and committed sufficient overt acts to convict him of conspiracy to commit the Hobbs Act robbery, but yet they weren't convinced that sufficiently of the proof beyond a reasonable doubt to convict them of possession of any of the firearms. Doesn't that tell us something about the potential weakness of the government's case overall?
So I don't agree, Your Honor, but I think at the very least I will acknowledge that it means that the jury drew some distinction here. That's clearly the case. But in this posture, this court doesn't need to speculate as to why that distinction was drawn. The questions presented here are with respect to any of these appellants, including Mr. Ashetu, whether or not he has shown a reasonable probability that he would have been acquitted based upon the claims actually raised by appellants in their motion for a new trial. And so with respect to whether or not he could have raised an entrapment defense, would that have raised a reasonable probability of acquittal? We submit clearly no. There's nothing to even get him through the door of derivative entrapment. With respect to the Spanish language audio, again, we submit no. I mean, he's captured on video at that last meeting participating in all of this, and then he gives statements and directions in English. So
let me make sure I understand your argument about derivative entrapment. So let's suppose at the trial, the entrapment instruction had been given, and with respect to Mr. Lovo, the jury acquitted him. And we know from, say, a special verdict form was used, we know with certainty that they acquitted him based on the entrapment instruction. But they convicted the other two. You would say that that would be a completely permissible outcome, and just because he was entitled to the instruction doesn't mean that the other two would have been entitled to the instruction?
So, yes, is the short answer. But to elaborate, first of all, of course, the government's position is that none of them would have been entitled to these instructions. But given Your Honor's hypothetical that the court believed that that threshold had been met and was giving instructions, the only type of instruction that possibly could have been given for Mr. Ashetu or Mr. Sorto on this record would have been a derivative entrapment instruction. And I would direct the court's attention to the Washington case that this court had in 1997, which expressly, the scenario in that case was it was investigating a potentially corrupt police officer. And there was discussions about him recruiting others to be involved in his illegal scheme, but it was all in generalized discussion about recruiting others. He recruited others. And this court held that they were not entitled to derivative entrapment as a defense, as a matter of law, if there was no evidence that the government had specifically targeted them for involvement. because their involvement was because their friend invited them. There was no government action overbearing their will to engage in illegal activity. And there's nothing that's been proffered or presented, and certainly not in the trial record, indicating anything other than that Mr. Sorto's and Mr. Shetu's involvement in this case was solely at the invitation and the behest of Mr. Lovo, which does not establish, as a matter of law, derivative entrapment defense. Do you see I'm over time? If your honors don't have further questions, we otherwise rely on our briefing and ask that the judgment of the district court be upheld.
All right,
Thank you, Your Honor.
thank you. I believe that appellants counsel were both over time, but give each of you 2 minutes.
Thank you, Your Honor. The government has stated the defense counsel could have ID'd disputed facts, but that's exactly what we needed the hearing for. The government counsel also stated there was no mention of a robbery until August, but we actually don't know the type of pressure that was given on them. And that specific robbery was not mentioned until August, but that doesn't mean that there wasn't pressure to do a robbery starting in May when they first started conversing about this. And there is some indication that there was some conversations about that.
In the record was proffered that there was inducement that happened before August, whatever that date was, August 13th.
Yes. And a lot of that has to do with the pressure from the 131 phone calls that occurred before that at the government's behest by the co-defendant, but at the government's behest. It wouldn't have happened had it not been for the government. As for the issue of the entrapment for Mr. Shetu in particular, there's nothing in the affidavit, so that you can't make a determination as to why his counsel did not pursue that, because there was nothing in his counsel's affidavit on that at all. During the entire time that there were these conversations, the agent was constantly discussing accrue, which is the derivative entrapment here. They were constantly discussing, we need accrue, we can get people, you can get people, and that is how the derivative entrapment came about. The way the evidence was presented was as to the Spanish language tapes, was that the government could understand what was going on, and they were the only ones that could understand what was going on. And so everybody had to, that they could hear it, nobody else could. And so we just had to believe what they had to say without any looking carefully at that. Deficiency and prejudice are closely connected, because only once one knows the degree of the deficiency is it possible to determine the prejudice. And that's why you needed to have the hearing in order to be able to determine what the deficiency was, in order to be able to determine the prejudice. And finally, I would like to say, as Judge Wilkins suggested, the prejudice, the court found that in 2017, they couldn't find prejudice, and they couldn't determine if there was prejudice. And they sent it back to the trial court to determine whether there was prejudice or not. And we cannot find here now without having held a hearing, because the affidavits didn't answer the questions that were sent back to them. The affidavit didn't discuss what conversations they had, whether the appellates advised. The affidavits could not possibly have discussed whether the appellants advised their counsel that the testimony was not an accurate account of the conversations. The appellants had to be the ones that would be testifying as to that. And there was nothing showing the extent of prejudice from not objecting to the Spanish language tapes.
I think we have your argument.
So we, at this point, would ask that you would reverse and remand. Thank you.
Thank you.
Thank you, Your Honor. I'll try to be brief. So the phone calls were not explored on the record when my client testified at trial, because the lawyer didn't know about the phone calls, didn't have the phone records. He didn't ask him about his full-time work because he didn't have those records. In terms of the inducement, July 24, 2012, there's a small transfer of drugs. My client and the snitch, February 7th, 2013, another small transfer of drugs. That's when the snitch, February 7th, 2013 is the first time the snitch introduces the undercover
You mean
officer.
the cooperator?
Yes, sir. The cooperating, the young man that had nothing to do with this offense and was working to try to get time off. So February 7th, 2013, the young man brings into the conversation the undercover officer, February. After several months of nothing happening, the undercover reached out to my client, and Lobo's testimony is that he told him that he had recently purchased a storefront of some kind, and he wanted his advice on how to remodel. And in fact, it is undisputed that the undercover at that meeting took my client to a shop at the 600 block of Florida Avenue and told him, this is my shop that I'm trying to remodel. The first meeting that the officer says they talked about the robbery was August 13, 2023, at a restaurant. That meeting was not recorded. That meeting was not recorded because the agents decided not to record it. And as with these reverse sting operations, they did it in hundreds of cases throughout the country. This goes to the selective enforcement. All the defendants, 99% of the defendants were Blacks or Latinos. They brought them to this restaurant. They gave them alcohol, and and conversations took place. And with respect to the entrapment defense, one of these cases, and they're identical, including these officers, was tried in the Eastern District of Virginia, and an acquittal resulted on an entrapment defense. I can submit that case to
None
the
of
court.
that's in the brief.
I don't think the acquittal is in the brief. But the fact that they plied them with drugs and with alcohol at these meetings and this other stuff, this was before the district court, and this was in the motions that were presented post-trial for a new trial.
All right, we have your argument.
Thank you, Your Honor.
The case is submitted.
Case number 24-1071 et al. Grand River Dam Authority petitioner versus Federal Energy Regulatory Commission. Mr. Zetlin for the petitioner, Mr. Wilkins for the respondent, Mr. Gossett for the intervener.
Morning, counsel.
Good morning, Your Honor. Misha Tselin for GRDA. The Pensacola Dam has two functions as relevant here. One, we use the dam for power generation to service our larger rural customers in Oklahoma under the supervision of FERC. Two, the U.S. Army Corps of Engineers uses the dam for flood control operations for the benefit of the entire Arkansas River system by telling us to open and close the gates in the Corps' discretion. All of the disputed flooding here, to the extent it's not just caused by natural causes, is caused entirely by the Corps' flood control operations, not by our power generation operations.
Counselor,
Yes,
before we get into the facts of this, I'd like to talk about standing for the authority. So here, the brief doesn't say very much about this other than that the authority is the object of FERC's action.
Yes, Your Honor.
But in our decision from a few years ago, remanding this to FERC, we asked FERC to do a variety of different kinds of legal analysis about the statute and the underlying license, which they did. So what is the direct injury, the concrete and imminent injury that the authority faces at
Well,
this point from FERC's current decision?
I mean, we have to conduct various studies, which are going to cost dollars and cents.
Didn't the authority already conduct the study and submit a report to FERC?
No, there are additional studies being required just during the pendency of these proceedings. They required more from us under submit more data, more stuff under the orders on review. If we,
Can I ask,
yes,
have those reports been submitted as well?
we updated them with additional data just a couple of months ago, and we responded to them and said, hey, why are you asking us for this data? We're on appeal before the DC Circuit. And they basically sent like a letter saying, no, give it to us. We wouldn't have had to do that work.
Did you seek to stay those requirements while this appeal was pending before FERC? I don't know if that's a mechanism that was available.
We claimed that because were before this court, they didn't have the authority. Then we asked them in that letter, use your discretion to stay this. They sent us back a pretty nasty letter saying, no, give it to us now. And then we went ahead and gave them the additional data that they wanted.
But the authority hasn't been required to purchase any land for flood control. I mean, they haven't been asked to acquire land or to take any particular action yet by FERC.
That's correct, Your Honor. But if standing at minimum from the fact that we're subject to the study requirements in terms of redressability, if we get vacature of the orders on review, we will, of course, not have to produce any of that stuff, and we'll be done.
Well, we have a number of cases, though, suggesting that it's not an Article 3 injury to have legal reasoning that is harmful to a person, right? That the legal reasoning alone isn't the type of injury that gives Article 3 standing.
Well, not legal reasoning, Your Honor. The orders on review require us to do real stuff. I understand that in the stay context, this court, and frankly, why we didn't seek a stay in this court has held that just doing normal kind of litigation and things of that sort or even in the agency context, is not sufficiently weighty to trigger the authority of the court, trigger the discretion of the court to issue a stay. But certainly preparing data reports that cost dollars and cents, real money.
Can I ask, are there any data requests pending?
We responded to their letter request. We don't know if they'll ask us for more. Certainly, we're subject to.
I think that means no. There are no data requests pending as of now.
Well, I will attempt to update this court, on my rebuttal about what more we continue to do under the orders on review.
Let me come at it this way.
Okay.
My understanding of your argument that's at point 3 of your brief is that FERC erred by refusing to determine if it was the Corps rather than your client that caused the disputed flooding.
That's right, Ron.
That's the.
Yes, that they
In
violated.
broad strokes, that's your argument.
Yes, that they violated this court's remand instructions and didn't consider an important aspect of the problem.
And I didn't see in your brief where you asked us at this juncture to say, to make a finding, so to speak, that the flooding was due to the Corps' action, not Grand River Dam's action. Right? You're not asking us to find at this point that there's, insufficient evidence that Grand River Dam is responsible for the flood.
Yeah, the only thing we're asking for is vacature of the orders on review on that aspect, that they didn't answer this court's factual question about who's causing disputed flooding. And then that is further an important aspect of the problem under State Farm.
So the reason that I ask it that way is that even if we rule for you on that claim, what you would get is a remand, and FERC would appropriately go back and see, well, was this, check all the evidence that they allegedly overlooked and determine really whether this was, the Corps is responsible for the flooding as opposed to your client.
Yeah.
Right? And so I guess my point is that if you prevail on that point, then why do we need to decide points 1, 2, and 4 of that you presented in your brief? Because we don't know whether your client will be asked to purchase any land outside of the project boundary or to change the dimensions of the project boundary, or whether it's the Corps who has exclusive responsibility to purchase land outside the project boundary with respect to your client, rather than your client, because none of those things may ever come to pass. The project boundary may never change. Nobody may ever have to purchase any land, right? But why are we even talking about points 1, 2, and 4? Because even if you win on number 3, those other issues aren't ripe yet.
If we win on number 3, the orders on review will be set aside. It's a sufficient basis for us to win. But for example, if we win on number 1, it is undisputed here that if we win on 1, on the meaning of the Pensacola Act, it is undisputed that we already own all the rights within the project boundary. And if we are right about the Pensacola Act, FERC has literally no jurisdiction to do anything else on remand, because we already own everything within the project boundary. And if we are correct that the Pensacola Act is plain as day, that outside the project boundary, FERC has no power, this proceeding is over. We don't have to do anything else. We can all close up shop and just worry about the relicensing proceeding.
Even if that argument is a good one, as a matter of law, why isn't the right time to bring that when FERC orders you to purchase land or acquire land outside the project boundary?
Because we currently have orders that are final orders that if they are set aside on this basis, the proceeding is over.
But FERC hasn't even decided whether the project boundary should be expanded, right? It seems that at the moment they say, we think that the project boundary has to be expanded because of whatever flooding issue. And at that point, the dispute is ripe about whether, because it seems like you have an argument that once the project boundary is fixed, it's fixed and can't be expanded.
Mm-hmm.
And then you have a separate argument that if it's expanded, or if it's not expanded and there's land outside the project boundary that's being flooded, well, FERC has no jurisdiction to, address that at all. Somebody, that's between the Army Corps of Engineers and those landowners or whatever is how to resolve that. But the point is that why is any of that ripe right now, where we don't know whether FERC is going to expand the project boundary or ask you or anyone else to acquire land outside of the current project boundary?
And again, I don't mean to be repetitive. It's because there is no dispute that we own all the land within the project boundary. If this court holds that we are right as to what the Pensacola Act means, and this is not a long act, it's plain as day, the proceedings are over. We're not going to have to do anything else. And we wouldn't have to spend any more money, it would be done. And there are final orders that we petitioned, within our 60 days.
Explain to me why that resolves, why that would resolve everything.
I mean, maybe my friend will say something different, but as I understand it, it is undisputed that if there is a holding from this court that the FERC has no jurisdiction outside of the project boundary, that there was nothing else to be done here because we own all of the rights within the project boundary. The entire dispute here, and the one that Congress was resolving in 2019, was what to do with disputed flooded lands outside the project boundary. Congress said that is outside FERC's jurisdiction, which is what we were saying the whole time. Once Congress said that, this should have been over. Now, the first time we came up to this court about 4 years ago, FERC had agreed with us. And a lot of the arguments that I put in my briefs and I was going to present today, I presented to this court. And what this court said is, we need to hear more from FERC as to what this 2019 act means. FERC has now told you all what they think. Now, I don't think they actually did any textual analysis, but they've told you. The arguments are squarely presented. Congress tried to put an end to these proceedings in 2019. It said that outside of the project boundary, FERC has no jurisdiction. These proceedings are all about what is outside the project boundary. This proceeding should be over. We shouldn't have to submit these studies.
Mr. Salin?
Yes.
I find the Pensacola Act argument powerful.
Mhm.
But if the case is moot, the case is moot. Right?
But it's not moot, Your Honor. There are we have submitted information and there'll be additional proceedings from that information. Ending those proceedings that certainly cost us at least $1 to take part in is injury. What is causing that? These orders. What is the reachability? Vacating these orders. Those are the three elements of standing. So the proceedings would be over. We would save money. We're the direct object of those proceedings. We have to participate in those proceedings. And so there is standing. The case is not moot.
This next question might be unfair. We give you a heads up that we would be asked about mootness. I think there's some precedents that say something similar to what you just said in the context of an improperly appointed federal agency that being subjected to a proceeding before them is injurious.
Mm-hmm.
Do you have any good precedents for just being subject to an agency proceeding is an injury?
I mean, we're happy to submit some little briefs after this. I mean, you could see that we did not expect this to be an objection, given that we are in the middle of proceedings. They told us submit reports. There's going to be follow-up. There's going to be back and forth. This has a long tail.
I think the original order to do the research and present a full report probably was enough for an Article 3 injury. But now that report has been submitted, you can tell, just speaking for myself, I'm a little worried that now that report has been submitted, I'm a little worried that you're no longer being injured in an Article 3 way from FERC, even if there are some pending data requests that you haven't responded to yet. I'm not even sure that there are. I don't think just merely having to show up to a FERC hearing is Article 3 injury.
I mean, if it costs $1, I would think that it is. But it also, that would be a somewhat strange, I think, holding because this has a tail. So if FERC then issues another follow-up information request, I think there'd be no dispute. I think that there would be under these orders that there would, in a letter saying, hey, we need more, that would satisfy anybody's concerns with regard to injury, but then we wouldn't have a final order and we'd be outside of our 60-day window on these orders. And these are the orders that are causing us the injury. And so that would be a pretty strange trap to put us into, where, the specific orders on review clearly injured us by doing the studies and doing the follow-up and things of that
Is there
sort.
like a capable of repetition yet evading review exception to mootness here? Is that what you're suggesting, that they're going to continue to make information requests that sort of brings this out of mootness?
I mean, I think if the court finds that mootness is interpreted like this in a situation where the orders continue a proceeding that has a long tail that no one disputes will cost us dollars and cents to have to take part in. If the court thinks that having that kind of long tail isn't enough to maintain a case from being moot, then I think capable of repetition exception would be considered.
And so Sorry, did you say earlier that before FERC, you had asked for a stay of this report, asked them to sort of hold, the requirement to file a report, and they declined?
They asked us for certain additional data,
Mhm.
and we said, why are you asking us for this data? We're before the court, and we said, you have no jurisdiction to ask us because for the court. That was an argument. That was an aggressive argument. We also said, if you don't agree with that, at least use your discretion to stay it.
You did,
We-
is that in the record?
No, because that was
Afterwards.
after we petitioned, because we were surprised that they were continuing to ask us for information when their ability to get information from us is exactly what's in dispute here. But they asked us for it. And then yeah.
It might be helpful to submit that information to the court
We
in
would,
terms of showing ongoing harms.
we will absolutely submit that, and we'll submit anything additional. Now, I see I'm a negative on my time, and I haven't had a chance to talk about the merits. I don't know how the court wants to proceed with
Why
that.
don't you proceed to the merits? We'll give you a couple minutes.
Right. Well, with regard to the Pensacola Act, as I mentioned earlier, I think it clearly by its plain text resolves these proceedings. The Pensacola Act says FERC's licensing jurisdiction shall not extend beyond the project boundary. All the disputed lands here are beyond the project boundary. FERC has no jurisdiction there, so we can't do anything else with that.
But aren't there a bunch of instances where FERC has adjusted project boundaries?
Well,
I mean, even in some of the cases that you cited in your brief, were instances where FERC did just that, right?
in every one of those cases, with the licensee's consent, we, both in Section 6 of the Federal Power Act and more specifically in the Pensacola Act, it requires our express written consent, that's the Pensacola Act, to change the project boundary. We'll be clear, we are not going to give that consent for anything to do with addressing the Corps' flood control operations. So unless and until we give that consent, which we will not do for the Corps' flood control operations, there is no jurisdiction over the disputed lands. If that is not enough, the Pensacola Act also says that any lands outside of the project boundary shall not be considered part of the project. That's very important because a project is defined by the Federal Power Act as lands and waters and whatnot that are necessary or appropriate for the management of the project. That means that Congress is saying there that lands outside of the project boundary are not necessary or appropriate for the management of the project. That's it's explicit direction from Congress, which is the one that gives FERC all of its authorities. Now, the last time we were before this court, my friend for the city who was sitting over there said, well, look, the Pensacola Act is ambiguous because licensing jurisdiction could have multiple meanings. I think it's no wonder that argument doesn't appear in FERC's remand order or in any of their briefs here. That argument doesn't work. As FERC says on page 43 of their brief here, there is only one kind of jurisdiction here. It's licensing jurisdiction. So there is no ambiguity in the more recently enacted Pensacola Act, which renders Section 28 of the Federal Power Act completely irrelevant. My friends on the other side didn't even give a textual basis in the Pensacola Act for adding the proviso that the act applies only to future licenses. They just said, well, I think FERC says in its orders on review that the Pensacola Act, read by its literal terms, would violate Section 28 of the Federal Power Act. That's, of course, constitutionally impossible. Nothing Congress did in 1920 could have.
Can I ask you a question about the Pensacola Act?
Yes.
So the provision on project scope and boundary jurisdiction amendments, you point out that first sentence says that Commission may, consistent with the requirements of the Federal Power Act, amend the project boundary only with the express written agreement of the project licensee. So
Yes.
That's what you were talking about
Yes.
earlier. And then it goes on to say, if the licensee does not agree to a project boundary change proposed by the Commission, the purposes and requirements of Part 1 of the Federal Power Act shall be deemed to be satisfied without the commission's proposed boundary or jurisdiction change. How should we construe that sentence? What does it do? What does it mean?
It means that there is nothing else to be done. Once we say the project boundary shall not be changed, the fact that FERC might be concerned about something going on beyond the project boundary is immaterial. The earlier provisions, or the prior two, say FERC doesn't even have jurisdiction outside the project boundary. It has no reason, no basis to make us do anything there. So if we don't agree to extend FERC's jurisdiction by amending the project boundary, as far as FERC's concerned, it's done.
Or anything else you want to say on the merits, or any other questions on the merit?
I was going to ask one follow-up question.
Yes.
Back to mootness. You were talking about how some of the follow-up requests for information, you asked FERC to stay those requests.
Yeah.
But I would think that if FERC should have stayed those requests while this petition is resolved, FERC should have also stayed the demand for the original report while this petition was resolved.
I will provide more details on rebuttal, but I believe that some of that report and those studies were also being provided as part of the ongoing relicensing proceedings. And that because we have submitted our relicensing application, they had that information from that, including the report that we relied on. It was, was submitted in the latest update was 2022, but then they were asking for more updated information on that report, which is when we asked them, hey, I know you've got this, including from our relicensing proceedings, but we shouldn't have to give you any more information because
I'm worried that's a little out of the frying pan into the fryer, though, because now I'm wondering if the follow-up requests for information might also have been necessary for the relicensing proceeding, even if they weren't deemed necessary by FERC for this current dispute.
We'll submit the letter, but it's clear that the letter was addressing this. The relicensing proceeding application is closed. We've already submitted our relicensing. Our license, I think, expires at the end of this month, and we're going to be just going on the continuing Federal Power Act authority under our license. So we've already submitted our license. Those additional requests for information and any other ones that would be coming would presumably be related to the proceedings arising from these orders on review.
I guess just one other thing. I mean, is it the authority's view that it's inevitable that they will be required to purchase land?
Absolutely not.
No, right.
Absolutely not. I mean, this is the whole,
No, I mean, if we disagreed on the legal interpretation, I mean, if we agreed with FERC on if FERC's decision was allowed to stand, will FERC inevitably require the authority to purchase land? I think that goes to the imminence of injury.
Yeah, I mean, if this court, under the orders on review, we are responsible for the flooding caused by the Army Corps of Engineers, unless we experience a no rain situation for the next indefinite period of time and unknown in the history of the Arkansas River system. I mean, the reason that all of these dams were constructed was the massive flooding that was happening in the 20s and the 30s. Unless that happens, and if we're responsible for the backwater effect of not opening our gates at the direction of the Corps, it will be inevitable that we will have to purchase some land under their interpretation of the Federal Power Act, Standard Article 5, and the Pensacola Act. That'll be inevitable.
So,
Sorry.
I just want to make sure I understand your response to FERC's argument about Section 28 of Federal Power Act that says that the right to alter, amend, or repeal this chapter is expressly reserved, but no such alteration, amendment, or repeal shall affect any license theretofore issued under the provisions of this chapter or the rights of any licensee thereunder. So if I understand it right, FERC is saying that the Pensacola Act, one, we shouldn't be doing any sort of implicit kind of repeal, but even if we were, it shouldn't affect any license that had been issued prior to the effective date of the act.
Yeah, I mean, that,
If I'm understanding their argument correctly, so they would say that the Pensacola Act doesn't affect FERC's power with respect to your client's license. I just want to make sure I understand your response.
yeah, I mean, that is their analysis in the orders of review here is in the wrong legal framework. The governing case that this court should look at is the Dorsey case from the US Supreme Court. There was an old statute, I think from 1917, that said that any future changes to criminal convictions is only going to be, is not applied retroactively. And it said Congress needs to express language to change that. The US Supreme Court said, no, we're not going to require express language because there was a much more recent, more lenient statute. We're just going to look at the quote is whether there are necessary indicia of congressional intent that the new act would apply. Here, you couldn't have clear indicia of congressional intent absent an express statement, which Dorsey does not require, that Congress was attempting to resolve this very dispute. The fight that we had with Miami was started on the meaning of Standard Article 5 and FERC's authority under Section 6 and things of that sort. That happened in 2018, beginning 2018, early 19. The Congress comes in the next year and in a belt and suspenders way rejects every one of Miami's arguments.
But this statute, this Pensacola Act applies to more than this license, right? I mean, this isn't the only license that is covered by that amendment, right?
It's covered, yes, it covers both this license and all future licenses. Nothing in the text can be read, and they do not point to a word in the text that can be read to apply to only future license. What they're doing is using Section 28 of the Federal Power Act to blue pencil in a future license only requirement. The Section 28 of the Pensacola Act has existed for 100 years. Never once has either FERC or any court ever used the Section 28 of the Federal Power Act in that manner to blue pencil in with no statutory hook, no statutory basis, a future license only requirement on a statute that on its face applies to the current license and the future licenses, of course.
All right, we'll give you some time on rebuttal. Let's hear from counsel for the commission.
May it please the court, Jason Perkins for the commission. And since we started this on standing, we might as well talk about that first. So after the orders were issued, and you saw in the ordering language of the remand order, the only ordering language there is about the report that was ordered. The report was filed in November 13th, 2024 in docket number 1494-477. There was back and forth with FERC staff about the supporting files used to determine the backwater envelope curve parcel analysis in that report. So essentially the request was, okay, you filed the report, can you send us the GIS data that went into it so we can understand the report? So that was December 19th was the letter from FERC staff. Then January 21st was the response from GRDA saying that they didn't need to provide it. This case is currently before the DC Circuit, a number of other arguments that they provided there. Then February 18th, FERC staff responded and said that this is right from the letter from February 18th on page 2, that Commission staff's December 19th, 2024 additional information request does not modify the order on remand requirements, but only requests that GRDA provide the existing supporting information it relied on to conduct the requested backwater envelope parcel curve analysis pursuant to the order on remand. So it's just a follow-up. That's all that.
Are there any pending follow-up demands right now?
So the submission of the data that was requested from GRDA came in March 5th. I'm not aware of anything beyond that. And subdocket 477 is where the report is lodged on our website. It is after the rehearing order here, so it's not part of the record index, but it is part of the public record, part of the commission record.
Can I ask you from FERC's perspective, if this order, if the order was upheld, is there any chance that FERC would not require GRDA to acquire more land? Or is that basically inevitable based on what it's found? I mean, like the legal conclusion it's drawn, and then, based on, historical flooding and things like that. So your friend on the other side says, well, the only way we wouldn't be required to acquire more land is if flooding somehow stopped. So what is FERC's position on that?
Right. So I will say that the orders lead in that direction, that this is a case on remand. It was sent back to us to examine all the 4 issues, and the commission determined it needed more information on a parcel by parcel level to understand. And so it ordered the report. And a natural remedy for an Article 5 problem is to go get the property rights that the licensee hasn't already gotten. So all of that is obvious
So
from the face of the
that would
orders.
support
But-
Article 3 injury then.
But there's no guarantee that the commission gives in these orders about the scope, process, or impact of future acquisition. And it says several times that they haven't asked GRDA to go do that yet. So it's more of a timing issue than anything else.
So is there any question that if FERC did require the acquisition of land, then GRDA could challenge that?
That would be
And
an
the legal reasoning behind that order.
that would be an Article 3 injury once the order to get the further property rights is issued. Usually, as we saw in the City of Holyoke cases, there's a direction to submit a
Is there
proposal.
virtually no chance, though, that FERC will require the acquisition of land?
It depends on what the commission does with the information in the report. Since we're talking about an Article
Because we don't
3,
want to have, yeah.
since we're talking about an Article 3 issue, we can say that the report itself said that 880 acres would need to be purchased. And that's GRDA's perspective as to what the meaning of the FERC orders translated onto a property by property basis would be. So I think you're in a situation where if you are considering that as a potential injury, it would have to be a substantial risk of future economic harm type of injury to sustain standing now after the submission of the report.
Because FERC didn't challenge standing here.
FERC
I mean,
didn't-
we have an
right.
independent responsibility,
That's
of
right.
course, but FERC didn't raise this. So perhaps suggesting that FERC does believe there's a substantial economic harm.
So we considered whether this case was a candidate for abeyance because of this sort of situation where the proceedings are ongoing, they could result in Article 3 injury. There would almost certainly be questions, and there were raised some questions in the rehearing request about eventual scope, process, impact of a remedy. So is a third appeal inevitable here? Should we think about piecemeal litigation and holding us all until a final order on all of the potential issues are disposed of? But once the report came in, and it's GRDA's perspective that they have to get 880 acres, it seemed a little bit less certain whether or not the parties would support abeyance, whether or not the court would find that that's appropriate. If the court finds that there's no injury supporting standing now, then I assume the case should be dismissed.
If it's dismissed on that ground and then the authority is ordered to buy land and then the authority files a petition to challenge that, could the authority collaterally challenge the orders that we're talking about today when they challenge that future order to purchase land?
So I apologize that I'm not sure I have a definitive answer that I can give to that right now, but since we're talking about Article 3 cases and we're kind of off the briefs at this point, I will mention that there were some recent standing cases for cases decided by this court. If you're comfortable with me mentioning them, they're called American Whitewater and Industrial Energy Consumers of America, and they were decided in the last few months. One was American Whitewater was about a hydro licensee, and the court asked whether or not standing was appropriate for that licensee as an intervener, because the result of that order was no dam removal needed to happen in decommissioning. So there was a final decision about the licensee's responsibilities, and they intervened to support that decision. They were found to have standing. Industrial Energy Consumers, there were a group of electric customers who oppose an incentive given by the commission, but the incentive necessarily relied on later decision-making to actually take effect and actually have economic consequences. In that opinion, this court found that the interest in a collateral estoppel effect didn't support standing. And so that's why I'm not totally sure that I can give you an answer as to what the commission would do as to these issues later, because there are some conflicting precedents as to whether or not that the lack of
How is-
standing now.
Do you think that this case is different than industrial energy consumers?
Well, I'm not sure because there's a case cited in Industrial Energy Consumers, Alabama Municipal Distributors Group, that says sort of the opposite, that no standing now means you can challenge the rest of all the reasoning of the orders later. So there's.
It seems like that
tension.
would have to be the case, that you would have to be able to challenge the reasoning, because the reasoning would be what would be supporting the the order to acquire the land.
So perhaps it would be part of, it would support the eventual order that would say you have to procure land, but whether or not there's a legal conclusion that is part of that it relies on past precedent, I'm honestly not sure that I can give an answer right now as to whether or not that is something the commission would consider a collateral attack on a prior order. In some other instances, it is considered that, but under industrial energy consumers, there wouldn't be a problem. So I'm honestly not sure. I'd have to check. If you.
So what of the argument that notwithstanding any of that, we should forge ahead because with respect to issue 1, the Pensacola Act, if petitioners are right about the construction of the Pensacola Act, FERC has no more jurisdiction over it with respect to kind of this flooding issue. And so we should decide that issue now.
In terms of that supports an injury or?
Well, that I think your friend on the other side says that that's ripe and they have standing to pursue that claim now because that will end all of these proceedings, including all of the, potential, further requests for reports or studies and data, et cetera.
I'm not sure that having to participate in commission proceedings has necessarily been identified as an Article 3 injury, at least when you're a commenter who wants to object to something the commission did. I think generally speaking, the court has found that doesn't support the amount of resources you spend on administrative proceedings or litigation is not considered an Article 3 injury. When it's the licensee, I'm honestly not sure if that question is different because that's the regulated party responding, but it's the case that there is a lot of regulatory process related to all of our hydro licensees, especially when relicensing is pending. So it would be hard to identify like what's only responsive to this proceeding at this point until there's further process actually undertaken by the commission.
I asked you about FERC's interpretation of the Pensacola Act. We frequently have situations where the court wishes that Congress would get involved and say what it would like an agency to do. And it very much seems like that is what Congress did here, very explicitly. And then FERC, takes Section 28 and says, well, yes, Congress, does the Pensacola Act, but we're only going to apply it to future licenses. That just seems, the act seems quite clearly, there's nothing in the act that suggests it's only prospective.
I guess 2 responses to that. One, that was the commission's position the first time, and we were told to look at it again by this court, who said that there are 2 possible readings.
Again doesn't mean.
But those orders are not that was the square holding of the first round of orders, and this court sent it back to us and said the statute is ambiguous. Decide whether or not it is unclear to us whether the amendment strips FERC of authority to enforce the existing license or that FERC's authority to impose new conditions on future licenses limited. So automatically there's a problem if there's a clear statement rule in section 28, which is how the commission read section 28. It's unclear how you can take the position that our authority to enforce the existing license has been stripped by a provision that isn't
You
clear.
could interpret it, it's unclear to us as it is ambiguous in a term of art way that triggers some of these canons of interpretation that get triggered when there's ambiguity. You could also interpret it's unclear to us to mean we don't know. And if all the court was saying is we don't know if the Pensacola Act applies prospectively or not, or whether the Pensacola Act only applies prospectively, sorry. I don't think it's a holding that binds FERC in any kind of like law of the case sense.
Well, the processed gas consumers group case that we cited in our brief does tend to give law of the case principles to the prior case. I mean, I think that has been the practice in FERC cases that return back up to the court, so that you are looking from the starting point of what was decided in the first case to what was remanded to the commission and ensuring that we gave a reasonable response to all those things. I think that happened in this case. And as with
I
respect,
think holdings in a prior decision are a law of the case, but a line in a previous opinion in the case that says we decline to decide this issue, that's a holding that in some ways ties an agency's hand on remand.
I think that's certainly how the commission understood it
In this case.
In this case.
But the question is whether you were wrong.
Well, with respect, I think aside from whether or not it was a holding of the past court, if those are the two options, it either strips our authority into the existing license or our authority to impose conditions on further license is limited, then choosing the existing license option creates an implied repeal. That's what these orders are crystal clear about. And under the multitude of cases that we cite in paragraph 39 of our remand order, that is not the approach the Supreme
I think
Court wants
Mr.
us to
Stateland
take.
said that section 28's never been used in this kind of robust way to change to blue pencil a subsequent statute. Is that correct?
I think, well, we don't have many cases that cite section 28, probably because, as you see in other parts of the Pensacola Act itself and a lot of the other examples that are cited of project-specific legislation, Congress knows how to say notwithstanding any other law when it means that. And so it's even saying that in other parts of subsection B of this statute. And so when that language is absent from 3, what does that mean?
So I think the best language for the authority is the boundary jurisdiction amendments language.
Okay.
And I'm gonna, do a couple of ellipses here, but it says the commission may amend the project boundary only with the expressed written agreement of the project licensee. It just sounds very present tense to me.
And our reading of that is if you compare it to Article 2 of the existing license, that's a clear override of the existing license.
But then it's last in time and it controls.
Well, but that's the issue under section 28 is that we have to be certain. We have to have we essentially have to have certainty to the level that the Supreme Court would find that what Congress meant to do there was essentially overwrite Article 2 of the existing license when it didn't specifically say it was doing.
It didn't use magic words, but
the way
it seems like definitely the best reading, and arguably the only reading of this sentence is that it applies to existing licenses. The commission may amend the project boundary only with the agreement of the project licensee. It's talking about a project boundary that exists today. I mean, what could the word "the" be referring to if not the project boundary that exists today?
Well, I would point the court to the original introduced text of the Pensacola Act, and it included a more specific provision about what it meant by project boundary.
I think it's telling that your first go-to answer after that question was to go to legislative history. I'm not saying we would never look at legislative history, but I think you were doing the best that can be done to defend an interpretation of text that's pretty clear.
Well, I mean, also the fact that if that's the only indication that we have, then I think we're a little bit short of what Epic Systems from the Supreme Court would tell us. A little bit short of what Epic Systems case from the Supreme Court would tell us is necessary. Maybe we're then just trying to help, make more sense of what Congress did. And I don't know that that's our task here.
But if to answer Judge Walker's question, let's suppose 10 years from now, after the license has been renewed, this Pensacola Act is still going to be in effect. And this language would be talking about any amendment of the project boundary of that license at that time, 10 years from now, right?
Correct. And that's
50 years from now.
right. And that's why the commission said it can give effect to all the language. And that's why it's the most reasonable reading, is that it respects Section 28 and the Pensacola Act by giving the Pensacola Act effect on future licenses, including that provision, which would mean Standard Article 2 is not going back in future licenses. So it's all there. And that's why we're saying that that's what the Supreme Court wants us to do in this situation, that we are supposed to try and give effect to everything Congress has done. It may not be precisely what some people might think Congress meant at the time, but we have to be really clear about what we think Congress meant at the time in order to affect that sort of give effect to one and not the other.
Makes it really hard for Congress to get anything done.
I
We do this and we really mean it for right now.
Right, but the other sections of B are pretty clearly applying the type of language we would expect to know that we're talking about exceptions from a currently enforced rule. So the notwithstanding language in those sections I
told
think
you-
is helpful.
If I told you right now that you could amend your brief, do you think I'm only applying that to future cases?
Well, it would depend on whether or not you talked about this case or some other case. If you just said you can amend your brief, I've got a number of briefs in front of this court. So which case are we talking about? Which license? So I don't know that that's necessarily dispositive. I think the issue is that if you look at the full text of what Congress was doing here, you can see under B, and there are sites that we can provide for this, the understanding of all three sections under B is best applied to future licenses. And the reason why is that under B1, federal land, under current understanding of the project, there's not federal land under the current license. There will be federal land on relicensing. You look at JA 998, they're identifying that there will be federal land involved in the license going forward, and there currently isn't any. Under B2, those requirements there, the text says the commission or any other state or federal agency shall not include any license for the project. Well, we have to be talking about a future license there because we've already issued the one in 1992 that's still in effect. So include in any license means when you're issuing a new license. And then you get to 3, there's no notwithstanding language, and there's no language that means we're definitely talking about new licenses or definitely talking about the existing license. And so you get the implied repeal question. So that is essentially what makes sense of all parts of B and Section 28.
Is it possible? Well, that's all right. I'm good.
All right. If you want to make any concluding remarks, you can. Otherwise, we'll hear from counsel for the interview.
Say that if the court reaches the merits of the case, we think a reasonable place to start is with the finding on causation, which identifies that there's a problem here that is caused by the flooding, which is an issue that has been remanded to the commission, and the commission made a determination on the evidence. In terms of what else the court decides to address, it may depend on which results you reach and whatever other order you think may be useful. But with that, thank you for your time.
Good morning, Your Honors. May it please the court. David Gossett for the City of Miami. Given the questioning so far, I hope briefly to talk about four issues. I'm going to start with standing, which is obviously something that has interested the court quite a lot. I don't actually have much to to add to what I said. I was going to focus the court on the fact that even under the authorities' submissions, they acknowledge that there is flooding on 880 acres of land in the city. There's a dispute about whether it's 880 acres or 13,000 acres, but that is something that we think will get resolved going forward. I also
So
think it,
inevitably, under anyone's view, they would have to acquire some land.
That
Under
is- I-
FERC's legal interpretation.
under FERC's legal interpretation, I think it is inevitable that if this court affirms that, the city will have to either acquire land or acquire flowage easements.
Mhm.
But I do think that if the court dismisses for lack of standing, there is no question in my mind that the authority could challenge the legal conclusions here in those future orders. I don't know if I would call it a collateral attack or just the fact that they are incorporated into that. The last thing I'll say on that is I think everyone before the court would love some closure on these issues because obviously it will affect what happens below and it might clarify how to proceed, but I'm not addressing the Article 3 aspect of that. On the Corps' role, Judge Wilkins, which you asked about, I think it's important to distinguish what the commission decided there, which is, I think, the only legally relevant question. The commission held below that GRDA will be legally responsible for acquiring land irrespective of whether flooding on that land is caused by GRDA's operations of the dam when it itself is controlling the dam or when it is operating the dam under the direction of the Corps when the water is in the floodplain between 745 and 755. That was the question that was unclear before, but the commission has now clarified that that's its view and that that's the Corps' view as well. It's also the view that the courts in Oklahoma have similarly taken in private litigation about that. So I think that the question of the Corps' role has been adequately resolved for purposes of assuming there is this flooding and assuming the Pensacola Act, which I'll turn to in a second, doesn't address that, the authority has to deal with that flooding.
So your argument is that even if your friend on the other side is correct that the flooding is due to the Army Corps of Engineers action or their direction, it's immaterial because it's flooding nonetheless, and FERC's view is that Grand River Dam Authority will have to acquire new rights or easements or whatever bundle of sticks is required to address that flooding, regardless of who's responsible, so to speak.
Yes, because flood control is a project purpose, and the authority, when it accepted the license, accepted responsibility to own all lands necessary and appropriate for project purposes, including flood control. It knew that there could be flooding from the property, and it accepted it accordingly. I think on this, it's also worth flagging. Part of the reason there is this flooding now, regardless of whether the Corps controls it in this narrow range, is because over the course of the last 30 years, the authority has raised the average level in the reservoir significantly by 20 feet or more. And that means that there is much more likely to be flooding, be times when the water is in the flood zone. And therefore, when the Corps can say, okay, we don't want to flood downriver, we're going to flood upriver. That's basically what the Corps is deciding, is who to flood, not whether there is flooding. It's because the Corps is saying, okay, the water's too high in this reservoir. What are we going to do? Do we flood downriver? Do we flood upriver? So that's part of the reason why it doesn't make sense for the Corps to be legally responsible. Finally, of course, to the extent there is anything to the authority's arguments about that being the Corps' responsibility in some sort of takings theory, the appropriate route for that would be for the authority eventually to bring a case in the Court of Claims for such a taking.
Is the level of the reservoir, when you say that the authority has raised the level of the reservoir, does that determine whether the flooding is, down of the reservoir or upstream of the reservoir? I didn't
No,
understand.
no,
the
sorry,
relevance
I
of
was
the- of
probably
the
was not
raising
very
the
clear.
reservoir. Sorry.
At the moment, the rule curve for the reservoir, which is basically where the water is normally supposed to be, ranges between 742 and 744 feet. Then if there's a lot of rain, the water is going to go up from there. It used to be the case that the rule curve, where the authority set the reservoir level at a general basis, was in the 730s. It generated less power, so the authority made less money off
For
of
the
power.
power, that was the
Yeah,
reason.
I mean,
Okay.
it's
I didn't
power
understand
power and recreation. I mean, it's a bigger reservoir now. There's more space for boating, et cetera, if the water is higher in the reservoir, because the reservoir is basically a lake. So there were reasons why the authority wanted to raise the reservoir. They generate more power,
That was.
but
I
it
didn't
causes.
understand. Okay, thank you.
Turning to the Pensacola Act, which is obviously, if you reach the merits, the most important question here. I think there are definitely two ways to read this act, which is what Judge Silberman held. Judge Walker, you said that this authority's interpretation is powerful, and it may be, but I think that's not the question. The question is whether Congress impliedly repealed Section 28 here, which, and there's a general principle against implied repeals, and here we have the added benefit of what we're talking about impliedly repealed is Congress's pre-commitment, which is pretty fundamental to the whole structure of the Federal Power Act, that we don't change rights and obligations of existing licensees once they get a license. That's the principle that we're talking about here, is that when they got this license, these were what they were allowed to do, and this is what they must do. And so,
Isn't it completely consistent with that principle to read the statute as the petitioners have asked us to? I mean, number one, this doesn't seem like the typical implied repeal case, because here Congress defined project to be this specific project that they are talking about, that they are regulating. So there's nothing implicit about that. That's very explicit.
yes.
And then they say that's what project means. And then in project scope, they say if the licensee does not agree to a project boundary change proposed by the commission, then that's it, basically. And it says amend the project boundary. So we might have thought that it was ambiguous before, but that doesn't preclude us now from saying the best reading of the statute, now that we're not doing Chevron deference to an agency, is to say that they meant this project and the project boundary as it existed on December 20th, 2019. And this was signed into law.
I have both a legal answer and a factual answer. The legal answer is that I think, obviously, no one is claiming Chevron deference. We all understand we're out of the Chevron world, and no one's even claiming that this is the sort of factual question that under Loper-Bright might still get deference to what the agency has said. This is a question of what the statute means. But I think that Section 28, as a clear statement rule, as a pre-commitment, it's sort of like the major questions doctrine. It's to the extent there's any reading of this law that doesn't fully run roughshod over the text of the law, under which the existing license obligations aren't changed, the court must endorse that reading. It's not about what FERC said. I'm not saying that you owe deference to the commission or to Mr. Perkins' argument. It's that you owe deference to Congress's statement and to the principle of 100 years of statutory interpretation or more that implied repeals are disfavored, and that this has to be viewed as an implied repeal of Section 28 to the extent
The
it.
other principle you said governed here is that there was a principle of like, making sure that licensees' expectations and the expectations of their investors in these projects, et cetera, aren't unsettled. I mean, isn't this Congress saying that we are going to make sure that those expectations are not unsettled here because we're not going to allow a project boundary amendment unless the licensee agrees?
The Congress was also presumably paying attention to the rights of others, or the obligations as well as the rights of the project. And on section, I guess it is B3C, which is where you're focusing about project boundary amendments. I think that's where it's worth looking again, as Mr. Perkins did, at all of the language of the statute and how B1 has nothing to do with the current license. There is no federal land on the current license. B2 license conditions says that you shall not include in any license requirements relating to surface elevations. The current license has requirements about surface elevations. That's the rule curve. So this is saying don't put this into a license, but it's not saying remove it from the license that's already there. There's no reading of B2 that applies to the current license. Then B3, the project scope language, B3A says the licensing jurisdiction of the commission shall not extend outside the project boundary. And that's what I think it is reasonable to interpret as being about the new license. There was the relicensing proceeding ongoing at the time the Pensacola Act was passed. So this could be about, you're having all these fights, let's work these out in the current license, and then it's set. We're not going to have this fight going forward. And then B3, B, and C are part of that project licensing. On project licensing, I should also flag, an entirely different part of FERC deals with project licenses versus complaints on existing licenses. They're different offices and different people. So talking about the project licensing really does make some sense only if it's interpreted as being about the new license. So I think it's unfair of the authority to argue that we haven't focused on the language of this statute. I think we do, and it does apply. Yes, B3C says that the authority gets to reject project boundary amendments. The question is just, are those project boundary amendments under the current license or under the new license, or both? And we think that it is a perfectly plausible reading, and therefore under Section 28, the reading the court must accept that that applies to the new license only.
I mean, implied repeals are just favorable. It's just one way of reading statutes over time. Another one is that more specific statutes control more general statutes, right? And, we shouldn't read new congressional enactments overly narrowly to give them no effect because of a almost 100-year-old statute. I mean, there are a lot of principles that we apply in understanding how two statutes work together over time.
That is, of course, true. We learned that in law school, but it doesn't change the fact that there is that the implied repeal rule, and that here, what we're talking about impliedly repealing is actually itself a rule against implied repeals. So you're saying, don't impliedly repeal a rule that says we don't impliedly repeal existing licenses. We don't change licenses. And I think that's particularly powerful. Sorry, you have a follow-up question before I say my next point, which is slightly off.
I know, I don't think that the rule against implied repeals means that any plausible reading that doesn't lead to a repeal is the one that we must adopt. I mean, I think we're trying to figure out the best meaning of both the Pensacola Act and, Section 28 and how they fit together. And the best meaning might not just be a meaning that's plausible because of a rule against implied repeals, is what I'm saying.
That is, of course, true. It's on this, Pache Judge Walker, the only legislative history that exists of the Pensacola Act is a one line in the conference report that says this is about delineating the scope of the core versus the commission. That's all that the legislative history says. So Congress as a whole.
I mean, that may be all the legislative history says.
I-
The history surrounding the amendment is not good for you. I'm not saying that we should go beyond the plain text
I'm not
and
either.
inquire into that, but that history is something along the lines of people like to have fun on the lake with their boats. People who do that don't really care whether Miami gets flooded. They had, and probably have, more political power than the people in Miami have. So they use that political power to get a bigger lake for their boats. I'm not casting a value judgment on that, but that would be quite consistent with the meaning of the plain text as the authority has described it, although I suspect that the authority would not like that explanation for how the law became the law.
To be clear, the authority can continue to flood this land. They can keep the water where they is. It's just a question of whether the costs of that should be allocated to all of the ratepayers or to just the city.
And if I were a policymaker, I may well say, let's impose the cost on the people who are flooding other people's land. But I'm not Congress.
That's why I think the fact that this is sort of one small provision in a 1,700-page bill that is never described as doing what you just said does have some bearing in how the court should think about Section 28, because I think that's, again, where we go back to. Section 28 was passed by Congress when they first set out the entire way that they incentivized people to build dams in this country. And it's existed that whole time. It has been interpreted. I think the case I'd point the court to is this court's Montana case from 1970. What the court held in that case was that it was okay to change the structure by which someone's rights were remedied. It used to be the case that if you had if there was a claim that you had done something wrong, the licensee had private arbitration to decide if it was okay. Then after that license was issued, FERC was created and the law was changed so that FERC decided it and then there was appeal to the court. And the court said, okay, that procedural change is okay because it's not substantive. It's not changing substantive rights or responsibilities under it. But actually, if you read the Montana case, it suggests essentially that a substantive change in the rights or obligations of a licensee might actually have constitutional problems. So I think
What would be the constitutional problem, though? Because the Pensacola Act is still prospective. It's not changing.
I think it was, I mean,
what
to be
would
clear, in that case, it was changing, taking something away from the licensee that they had or that they claimed they had. And then it would be sort of a takings or a contract violation would have been the theory there. But the obligations similarly are bound by Article 28. No one's claimed that it's only about their rights. It's also their obligations.
I only ask this because I think you can answer it in 10 seconds. It's not worth more than 10 seconds, but there's a Pensacola, something spelled like Miami, and a Disney all next to each other. Is that a coincidence? You know how they all got these Florida names?
Miami is actually a tribal name.
Well, it's in Florida too.
And in Florida too. So the Miami tribe was there. I have no idea how Disney got there,
Okay.
but Miami is a tribal name. So, and in fact, there's a representative of the tribe here.
I got that.
If there are no further questions, thank you so much, Your Honor, and thank you for the time.
Mr. Sutton.
If I may, Your Honor, I think the threshold issue has been discussed here in terms of standing. I think it's actually an argument of mootness, and that's quite significant. There's no real dispute that there was standing when we filed this petition. When you have a question of whether a case becomes moot, the presumption flips the other way. So if the court thinks that there is now a case that where we clearly had standing at the beginning has become moot, we would ask for supplemental briefing. To the extent that I have anything to add to say before is that in this order on review at JA 1038, FERC specifically reserved the right under these orders to require more reports, supplemental information, et cetera. During the pendency of proceeding, they've already exercised those rights. So I think that that will be sufficient to rebut the presumption that the case that wasn't moot before has become moot. But I would ask the court to permit us supplemental briefing on this issue, since it is not a standing issue, it's rather a mootness issue.
How fast could you do it?
As fast as Your Honor wants. Now, with regard to the merits, my friends keep talking about
Sorry, if you're going to do supplemental briefing, if you could also address sort of the imminence of any economic harm of acquiring property, of being required to acquire property.
Absolutely, Your Honor.
We'll issue an order that sets forth what we want supplemental briefing.
Thank you. Quickly on the merits, my friends keep talking about the umpire repeal doctrine. I think the reason they keep talking about that is they can't actually win on the controlling doctrine. The Dorsey case from the Supreme Court is exactly on point. Also a statute 100 years ago. That 100 years ago statute required an express statute in the future. The U.S. Supreme Court rejected that requirement. The only way they can win, I believe, is a magic order requirement or a very stringent notion of clear, unambiguous statement. That's just not what Dorsey says. And the reason that Dorsey essentially took out the express requirement that had been in the 1917 statute is they said, we got to respect the fact that the dead hand of our prior Congress can't bind a new Congress. The only time that we've been able to find that Section 28 was discussed in a case before this court was the PG&E case written by then Judge Ginsburg, future Justice Ginsburg, joined by Judge Scalia. And the only thing that this court said about that was, well, they purport to, the prior Congress purported to bind future Congress. I think suggesting that to the extent it was effective, it was not very effective at all when you have a future Congress acting as it did here. I had a little bit of time travel here when I heard my friend from Miami bring back this licensing jurisdiction argument. I think there's a reason that that wasn't in the orders below or any of the briefs here. There's only one kind of jurisdiction that FERC can exercise here, as they say on page 43 of their brief. That's the jurisdiction that they do not have outside the project boundary. I also heard my friend say something about 880 acres. Those 880 acres are entirely the result of the Corps' flood control operations. While my friend does not believe that is a relevant consideration, this court in the first go around clearly did. It asked for a factual determination by FERC that FERC refused to then give on remand. And it even said why it wanted it. This court cited Arkansas Game and Fish Commission, which is the case that says the flooding by FERC of land, even if it's temporary flooding, can be a taking. And what do you do when the federal government takes your land? You go to the Court of Claims and you sue, which is what they should do if they have a problem with anything that the Corps is doing. They do not have any claim against us where we are acting only as an agent of the Corps when we're opening and closing those gates when it gets above 745 feet. Thank you, Your Honors.
Case is submitted.